CCT has convicted the suspended Chief Justice of Nigeria, the CJN, Walter Onnoghens, and banned him from holding any public office for the next 10 years. He was convicted on 6 counts of false declaration of assets. The CCT chairman, Danladi Umar, during Thursday's proceeding, held that Justice Onnoghens was not being charged as a judicial officer, but an ordinary public officer, and as such, the ruling of Justice Ngajua against the federal government does not apply to the tribunal. The tribunal had convicted Justice Onnoghens and removed him from office as the Chief Justice of Nigeria, the CJN, and Chairman of the Code of Conduct Bureau, the CCB. Emmanuel Anene and Tochukwu Ohazurike, both legal practitioners, join me from our Abuja studios. I want to thank you, gentlemen, for honoring my call to you at this time. Let me begin with you, Mr. Anene. Were you surprised at this judgment of the CCT, and why?
Well, good evening, Nigerians, and it's a happy Good Friday to all Nigerians. Yeah, going straight to your question, I was not surprised with the way and manner. That is why I want to disagree with the former Director General of Nigerian Law School. He says he's much more interested in the substantive justice rather than the procedure. Then the litmus test there is that was the procedure engaged by the CCT was fair enough to elicit confidence by the people appearing before it that justice will be given? The answer is no. Now, having said that, if you look at the act establishing CCT, CCD is empowered by the law to receive access documents or the declaring access of public officers, examine those documents to find out whether it complied with the law. That is Section 4. Keep those documents and receive petitions from the public. Now, the CCB received that petition. CCB never investigated that petition. And Section 4 says, if it is necessary to refer it to CCT. Now, there is a proviso in that section that said, provided that the person concerned makes a written declaration affirming that it was a mistake. Now, the CCD treated it as a conviction.
Okay,
this is not true. This is the provision of the law.
Let me bolt in very quickly so that I can get the views of Mr. Ohazurike as well. Now, the case is being appealed by Justice Onnoghens on the grounds of jurisdiction, to which the CCT chairman, Justice Danladi, held that the Justice Onnoghens was not being charged as a judicial officer in this case, mark that word, as a judicial officer, but an ordinary public officer. And as such, the ruling of Justice Ngajua against the federal government does not apply in this case. Is that it?
No. If Justice Onnoghens was...
No, let me get the views. Let me get the views of Hajirike.
Of which established Justice Onnoghens was a judicial officer serving as CJN of Nigeria. He cannot, it's laughable.
I know you have a time to respond to that, but let me get Mr. Ohazurike's views to this. Did you get the question?
Yes, I did.
Please respond.
This. You cannot say that the chairman of the CCT cannot separate Justice Onnoghens' positions from being a judicial officer and just restrain him and call him and refer to him as only a public officer. It is not possible. It is not within his right, because as he stands, Justice Onnoghens, as at the date he was charged to court, was the serving Chief Justice of Nigeria. And there was no way you could not recognize him as such, as a serving Chief Justice of Nigeria. So it wasn't within the powers or purview of the chairman of the CCT to so do. But exactly what happened was that the president had made comments, the presidency had made comments, and the chairman of the CCT, being an appendage of the presidency, only had to take a cue from what the president has said and executed this early Easter comedy that Nigerians enjoyed yesterday. And that was exactly what happened. It wasn't a judicial process. The process was so flawed and unquestionably so. So it is clear that what happened was Justice Onnoghens' purported conviction is not properly so called what it should be. Because in that case, even the findings of the tribunal were not...
My apologies. What then does the Constitution prescribe in the instance of removal of a CJN or an ordinary public officer?
It is clear about the removal of a CJN that it's only by two-thirds majority of the Senate that it can be removed from office, not by a purported ex parte application that was moved before a Code of Conduct Tribunal chairman. And that was illegal. That was not within the views of what the Constitution anticipated it to be. And what happened was that it was just for non-declaration of assets and not false declaration. Even Umar, when you were doing your intro, you called it, he was convicted for false declaration of assets. And that's exactly what the chairman of the CCT called it. But it wasn't any false declaration. No evidence throughout the trial was led to show that there was any false declaration of assets. It was only non-declaration that he was charged with. How come the CCT is now finding him guilty of breaches that he was not charged with? So it's just a predetermined end that they just arrived at.
If I may just butt in quickly, Mr. Anene, Justice Walter Onnoghen turned in his resignation letter to the president on Thursday evening, a day after the National Judicial Council, the NJC, recommended that he be compulsorily retired for misconduct. Can he then be sacked, having resigned, in fulfillment of Chapter 8, Part 2, Section 306, which deals with resignation in the Constitution?
That is what we say, that the judgment delivered by CCT has so many flaws in it. Number one, you cannot give a judgment saying that a dead person who was buried yesterday should be killed, because that is what he did. The moment CJN turns out his resignation, the day it was received, that is the effectivity date of his disengagement from judicial services. And that is it. So his pronouncement is academic, it's a mere academic exercise. And having said that, if you look at Section 20 of CCT Act, then the tribunal, while the tribunal was hearing the matter, said he has no recourse to NJC. NJC recommends the appointment of the members of the tribunal of CCT. But they said NJC, they have no recourse to NJC. NJC cannot discipline them. They cannot ask them any question. And in any case, if you look at that ex parte order referred to my colleague here, that ex parte order, the order containing that ex parte order that Mr. President acted upon to remove Onnoghen by way of suspension was illegal, because no lawyer moved that ex parte order. And secondly, and most importantly, the CCT, if you look at Section 23 of CCT Act, did not empower CCT to recommend to anybody to replace somebody that has been removed. All these things are there. And the NJC is just looking. I don't know what's happened. But what I'm trying to say is this. It may be Onnoghen today, like the professor said, is about the substantial justice. I can't believe that there is substantial justice in this matter because of the way and manner the procedure was engaged.
I must thank you both, because we're really out of time. I must thank you both for coming on the show. Emmanuel Anene and Tochukwu Ohazurike, both legal practitioners, joining us from our Abuja studios. Many thanks indeed, gentlemen, for talking to us on the show, and to you as well at home, wherever you are around the world, for being a part of it. I am Gimba Umar, and this is State of the Nation. Bye.